First, let us go to amendments in general. Pleadings may be amended by adding or striking out an allegation or the name of any party, or by correcting a mistake in the name of a party or a mistake or inadequate allegation or description in any other respect, so that the actual merits of the controversy may speedily be determined without regard to technicalities in the most expeditious and inexpensive manner. That was what I was talking about. The purpose of the amended pleading is to correct any error, defect, or imperfection in the statement of your cause or causes of action. That is the purpose of amending your complaint. The same is true with your answer. You may have committed some imperfections. You may have made some statements there in your answer that need correction. So you file a motion so that you can be allowed to amend your answer. Same is true with the complaint. Now, your amendment may be a matter of right without asking permission from the court, or with leave of court. With leave of court means with the permission of the court. Without that permission, your amendment cannot be allowed. So there you are. Your amendments are of two kinds. Matter of right, meaning anytime you can amend your complaint. The second kind is amendment by leave of court. All right. When is an amendment? When is an amendment a matter of right? An amendment is a matter of right if done before the defendant has filed an answer. Get that? So, for instance, today you filed a complaint in court. The following day, you discover that there are some matters that need correction. That your cause of action was not stated with clarity. So you would want it to be clarified. Now, since you filed it only yesterday, you can file an amended complaint without asking permission from the court anytime today or the next day, as long as it is done before the filing of the answer. It is a matter of right. So, mula ko sa imo complaint after filing it to the court, nasa iyo pa. Ako ini i-amend. Okay. Like what I said, the amendment may be a matter of right, and of course, the amendment may be by leave of court. So, since the defendant has not yet filed an answer, you can amend the complaint anytime without asking permission from the court. All that you have to do is go to court and file your amended complaint. How do you notify the court that your complaint has been amended? In the preparation, your allegation, what you may have omitted and what you may have added to your complaint should be underlined. Or if you are using a computer, you encode those portions which contain the necessary correction and or additional statements in bold letters. That is to show to the court that that is the portion of the complaint that you have amended. But normally, the procedure is to underline that portion so that the court will know exactly in what paragraph of the complaint did you make the necessary amendment according to your appreciation of your complaint. Get that? So, diyan amo dyan taglong appropriate markings. The other is, di ba sa computer, pwede ba mo, pwede lain na font ang mo gamiton? No? Ordinaryo na font, abay ni. Pagabot mo sa amendment, lain na style. And that shows that that is the portion that you have amended. Pero, better ka dyan and i-underline. Alright. Now then, the amendment, if done after the defendant has filed an answer, that amendment cannot be done without asking permission from the court. That is what you call amendment with leave of court. So how do you ask permission from the court that you like to amend your complaint? Very simple. All that you have to do is file a motion. Motion for leave to file first amended complaint. And motion for the admission of the first amended complaint. So your motion should already contain your motion for leave to amend complaint should already be accompanied with your proposed amended complaint. Because normally you do this. Motion number 1 for leave to amend the complaint. 2 for admission of first, kung ikapila na nimo pag-amenda, kung primero pa, first amended complaint. There. So you put there, plaintiff through counsel to this honorable court respectfully moves that he be allowed leave to amend the complaint. The proposed amendment consists in deletion of the name of one of the defendants and excluding him from the complaint. Then, second motion for admission of first amended complaint. There are actually 2 motions in one motion. Motion for leave to amend and motion for admission of first amended complaint. Because your first amended complaint should already be attached to your motion for leave to file amended complaint. Of course, in your statement here, in the body of your motion, you should state that the amendments are properly underlined. There you are. So the court will know exactly what portion of the complaint did you amend, because he will see in the copy of the amended complaint that is attached to your motion the paragraph. And if paragraph 10, for instance, contains underlining, that means that is the portion of the complaint that had been amended, and which is the subject of that motion for leave to file amended complaint. Okay? Sure. Kuya mo ninida mo, himuan na ako mga profesor. Kami may mag-explain sa profesor. Ada naman kami kasapi. Ini spoon feed. Alright? Now, formal amendments. What do you mean by formal amendments? Those are amendments about the form. Forma ra, appearance ra. Paralitan, wayak nimo ka numberi ano nga paragraph. That's formal. Dapat paragraph 1, no? 2, 3. Nagsugod ka ng paragraph 1, pagkatapos sunodin mo ng paragraph 5. Those are formal. A matter of form. So you want those to be corrected. So, control ka ng complaint, the paragraphs are now consecutively numbered. Unlike in your original complaint, you started with 1 and then followed by 5. Formal radaon. Amo daw taglawang formal amendment. As a matter of fact, you can do it with your ball pen. With the permission of the court, of course, Your Honor, I committed a mistake. Instead of paragraph 5, we should read paragraph 2. You can do it with your ball pen, and then you will be allowed by the judge to initial it. Kung may peligro dito namin medyaman, numero naman doon ng paragraph. Get that? Those are what you call in law as para dako, ano na doon, immaterial na mga amendment, matter of form. Those amendments do not affect the merit of the case. Ang taglaw na substantial amendment are those which affect the course of action and defenses. Those are what you call substantial amendments. Tapos, you want to correct because the spelling of the word against was TS instead of ST, which most of you commit. Right common word against, it's always like that. Nagkakaroon gano'n. Down. Hindi, ma'am. Dapat down ari diri. Diba? So, kung naman daw na nimo amendment, those are formal, matter of form, appearance, wrong spelling. You know what? Wrong spelling, you remind me of the story about the couple. There was that husband who was a very tender loving husband. And so he told his wife, because it was a Friday, here, I will get out of the office before 5 o'clock. I will ask permission to leave the office at 4:45. Why? We will have dinner outside, the two of us. We will renew our pledge. Then after dinner, we will go to the movie. Naturally, the wife was expecting that afternoon, those that her husband told her will happen. So, nag-ilis na. So, 6 na naman. Yeah, man. Hindi ako makakabot ng bana. The husband failed to contact his wife because when he got his cell phone, empty na. But empty na sila. He cannot call his wife. So he tried calling his wife through landline. Guba sa kanila landline. Lepas nila tumutunog sa ako wife na iya ako tumutin ang ako boss kay mag-overtime kami. Sa lahat ng pagkasulti, he was able to go home at 9:30 o'clock in the evening. And when he entered their house, he saw his wife lying in the sofa, fully dressed. His wife fell asleep while waiting for him. And so he woke her up. Dear, sorry, dear. Sorry. Naglaong ikaw ng alas 4:45. Uli ka. Sorry, dear. Ya, ganun ako tugutin at powder tayo. Oh, ba niyo makamanawag? Manawag ko sana ako. Pero patawag ko, ba't ako pa yung charge ko? Sa landline pa dyan. Mas silang buto, kaudir, kumbili. Guba! Ano? Landline sa opisina. Go! Oo nga, nanihapon na ka. Nanihapon. Saan. So to make amends, the husband said, okay, it's okay. It's okay, my dear. I will be the one to prepare our supper here. We went to the kitchen. Indarya Mangaluma. Kaya nag-changing around the prepare dinner until finally he opened the cabinets. He saw a can of corned beef. Here! Swerte, daring pa yung corned beef. Corned beef. Basad. Dari lagi. Wanila. Pisos. Inapriyan ng baja. Tagdaong bra. Abayan ka dito. Suso. Diriya naman pa dito. Sad. Teli ko tuman. Iyak paggamit na ito mga anak. Hindi na ito tuman. Takaksa na ito nangyari na ako. Ano ba yun? Ang bilangan niya. Naghanap. Until finally, kita sila dito sa refrigerator. Naitlog. Lawan siya. Ay, swerte pa ka doon kita diyan. Tortillas na ka na pumunta ko ng cheese. At itlog. Kajari pa. Bakit sawa? Pero naghilo pa na yung sawa. Balik din siya. Jari, bada. Itlog. Sawa ng sawa. Anoon, ang kina. Sos! Pagkabuti dito sa rin, pagtanaw. Diriran po sluti. Waya na iloon na itlog. Sos, diriran naman ba na iloon na itlogin? May bali, jari sinampuran sa rif. Say, suko ka sa pagkasawa. Pagkabali ka doon ni Jesus. Gulay na. Sari-sari na niluto na pag-inisan na sa alas 2. Ay, Jari! Utang! Nay, bis kaya piki na! Wrong spelling! Diego! Why, how do you spell utang?
Utang. Ginagadulit.
Bis kayo dito sa ito, graphic ka? Narong spelling na gihapon, nakabot sa utang. O yan, i-pronounce ito na utang. Okay, I think you are sufficiently awake. And I'm surprised why you feel sleepy when our topic is very nice. Okay. Alright, amendment to conform to the evidence. Ini. Kasagaran hindi na provision sa una, panagsara ng abogado. You know, you can only prove matters that are alleged in your complaint or your answer. Get that? So only those matters that you alleged, that you stated, can be proved by any of the parties, whether plaintiff or defendant. But then, there are some lawyers who will insert other matters which he did not state in the complaint or in the answer. If you are a very clever lawyer, you will object. Objection, Your Honor. That is impertinent and immaterial and should not be proven because that was never alleged in the complaint. So that cannot be proved. That is correct. But then, the law says, if an issue which has not been stated in the complaint or in the answer is tried with the implied consent of the parties, then the party presenting that evidence will be allowed to prove it, notwithstanding that it was not stated in the complaint or in the answer. Why is that so? Because the other party failed to object. Now, that is what you call implied consent for the hearing of a matter that was not raised in the complaint or in the answer. Normally, you will be allowed Normally, you will be allowed to prove only those matters which you raised in your pleading. You will not be allowed to prove something that is not there in the complaint, something that is not there in your answer. You are not allowed to prove it. Why will you be allowed to prove it when it is not there? It should be there first. In the first place, it should be there so that you will be allowed to prove it. No? But then, if the other party did not object, because he graduated from San Beda, so he does not know. But the other party graduated from Bravo, Paste, at the University of Parola, where he is. He knows. So, he objected, I object. He will ordinarily be sustained. Wala pa daw siya, Jesus, Bukano daw, ikan sa San Pedro, ito may payo. Pahi-offer man ng proiba sa aligasyon na which is not found in the complaint or in the answer. So, if he does not object, that's it. You will be allowed without requiring you to amend your complaint or your answer. But if the other party will object, because he does not want to give his consent to include that issue in the trial, then you will be allowed to amend your complaint to conform to your evidence. In other words, you will be allowed to amend your complaint to include that matter which you want to prove during the trial, but which was stopped because of the objection of the other party. For instance, sa imo complaint, diyan ka makapangadyo ng damages. Tapos you are now trying to prove that you suffered damages. That will not be allowed because it is not alleged in the complaint that you suffered damages. Now, in the course of your testimony, you are now asking for damages. No, you cannot prove damages because you did not ask. You did not say that you suffered damages in the complaint. So, if that happens, you will be allowed to amend your complaint so that your complaint will now contain an allegation that you suffered damages. So, you will continue with your testimony regarding damages already. Amo dyan. Pero kung may objection because the lawyer graduated from San Beda, he does not know, ay, sige, panadyon, damages. Naghangaw-hangaw ra dito, ang abogado. Sige, tanaw ng complaint. May dirigida ang adyon na damages sa complaint. Kung nagpruiba man sila dito, don't ask. Trabaho mo na si lawyer. Tuyog-tuyog na ka ba sa pagsitan na iya mo ka ako doon at isir ka mo kanto sa korte basa ko amin record para may tuyog ako doon ang imo sulti dito sa korte na ang mga graduado sa Basti kaya mo daw basa isa pakabuyan ang kaladyoon ng hearing pag-memorize na bravo Basti na lawyer na ano man mo pag-ilan daw at preparahan mong ka ng isang kabuyan. So that is what is going to happen. If he does not object, continue presenting that evidence because there is no objection. It is as if he consented that that issue be included. Okay, that? Okay. Then supplemental. All right. Today you filed a complaint involving one promissory note. So it's like this: A versus B for sum of money. Collection, no? Okay. This involves B who borrowed money from B on several occasions. First, promissory note, he promised to pay A on June 1, 2023. He failed to pay. Sige, June 1, he promised to pay June 1. That's the amount of 10 million. Then, he got another loan in the amount of 20 million. He promised to pay it June 15. Okay? So, duha ka promissory notes. Now, June 1 came. B did not pay. So, A filed a complaint in court on June 10. On June 15, the second promissory note became due and payable. So, supot na sa siya. Yabang bayad, A may now file a supplemental complaint covering the second promissory note. Get that? Para isara ka complaint involving already the two promissory note. So, the second promissory note is a cause of action that was not yet there when you filed the original complaint. But then, the original complaint was overtaken by events. A supervening event occurred, and that is the second promissory note matured. So in order to avoid multiplicity of suits, A here will be allowed to file a supplemental complaint covering already the second promissory.